Enhancements for repeat offenders in drug cases. Habitual offender laws and consequences in Texas. If you have already been convicted of a drug offense in Texas, any new charge puts you in a far more dangerous position. That's because under Texas law, repeat drug offenders face enhanced penalties. And in some cases, those enhancements can double or even triple your prison time. Whether your first conviction was for simple possession or a serious felony like trafficking, being labeled a habitual offender gives prosecutors powerful tools to push for longer sentences, limited parole, and fewer chances for alternative sentencing. Today, I want to walk you through how Texas handles repeat drug offenses when enhancements apply and what defenses are available if you're facing charges with a prior record. So what are sentence enhancements? A sentence enhancement is a legal provision that increases the punishment range for a new offense based on your past criminal record. In Texas, enhancements are used often in drug cases, especially when you have already been convicted of one or more felonies and you have been to prison. Instead of charging you with a more serious crime, the state keeps the same offense, but bumps up the punishment range based on your prior convictions. That means a state jail felony might be punished like a third-degree felony. A third-degree felony might be punished like a second-degree felony. 2 prior felony prison trips can trigger habitual offender status, which carries 25 years to life in prison in some cases. These enhancements are used by prosecutors to basically apply pressure during plea negotiations and at sentencing. Who qualifies as a repeat or habitual offender? There are different levels of enhancement depending on how many prior convictions you have and what type of offenses they were. State jail felony enhancements. If you're charged with a state jail felony, such as possession of less than 1 gram of cocaine and have been previously convicted of 2 or more state jail felonies and went to state jail prison, your new charge may be enhanced to a third-degree felony, which means 2 to 10 years in prison instead of 180 days to 2 years in state jail and up to a $10,000 fine. Habitual felony offender status. If you've been convicted of 2 prior felonies and went to prison each of those times, other than for state jail felonies, and you're now charged with a third non-state jail felony, you face 25 years to life in prison. This applies even if your current charge is a low-level, relatively third-degree felony, such as possession of 1 to 4 grams of a penalty group 1 drug, like cocaine or methamphetamine. Repeat offender enhancement. If you have 1 prior felony conviction, your new felony charge can be bumped up 1 level in punishment range. For example, a third-degree felony can be bumped up to a second-degree felony, punishable as 2 to 20 years. Second-degree felony can become a first-degree felony, 5 to 99 years or life. These enhancements often come into play with charges like possession with intent to distribute, drug manufacturing, conspiracy and drug distribution networks. To understand how these charges originate, check out my video and post on possession with intent to distribute in Texas, conspiracy charges in drug crime cases, and drug manufacturing charges in Houston. Some other common drug enhancements in Texas. Repeat offenses aren't the only enhancement prosecutors can apply in drug cases. You may also face higher penalties if the offense occurred in a drug-free zone. You were armed at the time of the offense. A minor was involved, a minor child. The offense involved distribution near a school. You're currently on probation or parole. When these are combined with habitual offender enhancements, your exposure to prison time can become overwhelming. Here's how a basic drug charge might be transformed by repeat offender enhancements. The original offense, typical sentence with prior felonies with 2 prior felonies. State jail felony, less than 1 gram of meth, 6 months to 2 years normally, can become 2 to 10 years, or in certain circumstances based on one's history, 25 to 99 years or life in prison. This is why prosecutors will often use enhancements to increase leverage in plea negotiations, even when the underlying charge is relatively low level. Can a misdemeanor be enhanced to a felony? Not usually by prior record alone, but prosecutors may charge repeat possession of marijuana, paraphernalia, or prescription fraud cases more aggressively if they believe you've developed a pattern. For example, a third charge for marijuana possession may lead to some jail time. Repeated misuse of prescription drugs like Xanax or hydrocodone could escalate into possession with intent to distribute. These charges commonly appear in juvenile drug charges, prescription drug fraud, and possession of drug paraphernalia. How a defense lawyer can fight enhancements. An experienced attorney near you can fight enhancements by challenging the validity of prior convictions. Maybe there's an incomplete record, an illegal plea depending on the wording, filing a motion to suppress the priors, especially if your rights were violated in those prior cases, negotiating a plea to a non-enhanced charge, arguing for a diversion program, probation, or treatment. Humanizing your story at sentencing to reduce the punishment range. You are a person. If enhancements are based on a very old or unrelated conviction, a skilled lawyer can often persuade the prosecutor or judge to drop them or avoid using them during plea negotiations. What about expungement or record sealing? Unfortunately, felony convictions are almost never eligible for expungement in Texas. However, if you were convicted as a juvenile or received deferred adjudication for certain drug offenses, you may be able to have your record sealed, but only if you avoid new convictions. For help with your record, consult an attorney who can assess your eligibility based on the specifics of your case. If you're facing drug charges and have any kind of criminal history, the risk of enhancements is real and the consequences are severe. Even a minor new charge can turn into a felony with a long prison sentence if prosecutors invoke habitual offender laws.